Good morning, ladies and gentlemen, and welcome to another CDH webinar in our 2025 Employment and Immigration Law Series. For those who don't know me, my name is Imran Mohammed. I'm a director in the CDH Employment Law Department. The purpose of today's webinar is to discuss what Cabinet in the last 10 days approved in the form of the National Labour Migration Policy, as well as the Employment Services Amendment Bill. So this morning we'll be discussing the planned introduction of sectoral quotas in the employment of foreigners in South African workplaces, 2, the proposed restrictions on foreign business visas, and thirdly, the enhanced regulatory framework proposed by both the National Migration Labour Policy as well as the Employment Services Amendment Bill. I'm joined by a panel of CDH attorneys who will speak about the forthcoming requirements, including skills transfer plans, verification processes, and the implications of, and I didn't make up this name, it's what's called by the Department of Home Affairs, inverted commas, Operation New Broom, and you can make what you want of that. Whilst we'll be discussing all issues related to the new plans regarding immigration and how that impacts the workplace, here's a spoiler alert. Please don't expect us to call to dim the lights this morning, and there's no videos of politicians, we promise you, even though we're speaking about immigration. And also to quote the state president, we have no airplanes to offer anyone, or maybe that's an Oprah pull. But on a more serious note, an introductory comment as a backdrop to the discussion that we're having this morning is the following. We all know that South Africa has one of the world's highest unemployment rates. The latest reports that was presented by the Department of Employment and Labour indicate how shocking a situation we have in the country. Youth unemployment is estimated or is indicated to be in above 30% of the economically active population, which is scary in relation to the unemployment figures. Secondly, we know that the labour market remains segregated 30 years down the line in democracy along racial, gender, and skills lines. There's a fragmented immigration laws policy, and we see that all too often, and there's a lack of coherent labour migration framework that can be relied upon in relation to making determinations with regard to the employment of foreigners. So what government seeks to achieve with the National Migration Labour Policy is to balance the need for skilled foreign workers with the protection of South African jobs. And secondly, to address what is always a very emotive topic is public concerns about migration and employment. And then also to fulfill our regional obligations under the SADC protocols, which supports a freer flow of labor, particularly in the sub-Saharan region, and the International Labour Standards ILO conventions with regards to the employment of foreigners. So to help us unpack both the policy and the bill, allow me to introduce the panel of CDH attorneys who will be discussing this topic this morning, starting with Terran York, who's a senior associate in employment and immigration law, Lee Masuku, a senior associate in employment law, and Sasha Naidu, an associate also in employment law. Sasha, let's perhaps kick off the discussion with yourself. I've made a few general comments with regards to the National Labour Migration Policy, but tell us give us kind of a backdrop with a little more introduction to the policy. What does it relate to?
Right, thanks, Imran. So the National Labour Migration Policy is South Africa's first comprehensive policy, which is dedicated specifically to labour migration. It's the broader framework which will underpin South African labour migration laws and regulation. Importantly, now the policy refers to migration and not immigration. And this means, of course, that the focus is not only on inbound movement, but also on the exodus of people from South Africa. And here we're talking about South African citizens who seek opportunities abroad. The policy serves as South Africa's stance, or vision rather, on the movement of people into and out of South Africa for the purposes of work.
So on this aspect of exodus of South Africans who have left the country, Terran, can I just bring you in on that? There was a recent judgment of the Constitutional Court with regards to South African citizenship. That was the DA application on the confirmation. That judgment was handed down, I think it was in the last month or so. Just talk to us with regards to this aspect that session mentions in relation to Exodus and the Constitutional Court judgment. Just what that judgment says and what the impact of that judgment is with regards to this question on Exodus.
So what that judgment, that was a DA challenge, and from the Constitutional Court judgment, what came across was that the particular section of the Citizenship Act, I think it was, if I'm not mistaken, section 6(1) subsection A, was unconstitutional in that it automatically deprived South African citizens of their citizenship when they took up citizenship of another country. So what the Constitutional Court confirmed was that that provision was unconstitutional from the date of its promulgation, and the effect of that judgment is that South African citizens who lost their citizenship due to that provision automatically, their citizenship was automatically reinstated.
So tying back to the issue of Exodus, you had a South African person born in South Africa with a South African passport who leaves the country at some point. As a consequence of the provision in the law that was declared unconstitutional, and they had taken up dual citizenship or had acquired dual citizenship, they would have automatically lost their South African citizenship. But if they had sought employment with a South African employer, that individual would then have required a permit in order to be employed in South Africa. Is that a fair summary?
That is a fair summary, yes.
As one of the many consequences. So
Yes.
the effect of the judgment would be such an individual would now not require a permit because they hold of a South African passport.
Yes, their citizenship will be reinstated, so they automatically have the right to work in South Africa with any such work documentation required.
Fair enough, and that would also apply in relation to remote work outside of South Africa, of the South African borders.
That's correct.
Yeah, thanks. So Sachin, then let's get back to the policy. What is it that South Africa actually seeks to achieve with the implementation of the policy?
Well, thanks, Imran. I think you mentioned a few of the policy's aims, but just to set it out, it's roughly three main aims, right? The first being that it needs to support South Africa's developmental goals, right? And the second being that it needs to align South African policy and law with its commitments within the region and to the international community. And lastly, it's a rights-focused based policy. So it seeks to protect the rights of all workers, both foreign and local. And just on this point, Imran, we know that from the discovery judgment that all workers, including foreign nationals and local South African citizens, have the right to fair labor practices, and we see this in that discovery judgment. However, this has for the first time been expressly stated in national policy. It's a policy which is designed to ensure that migration is managed fairly, in an orderly fashion, and in a rights-based fashion.
Let's just pick up Sachin on this discovery judgment, and Terran, if I can get you back into the conversation. There was again a very recent judgment. I think it was in the High Court in the Eastern Cape with regards to the dismissal of a foreigner in a municipality. That matter went off to the High Court in an instance where the foreigner was terminated by the municipality. Just talk us through that against the discovery judgment that Sachin is referring to.
So in terms of it's a recent High Court judgment against, and what that judgment, the employer in that judgment terminated a foreign national's contract of employment. It did so summarily without providing the employee with any notice period, and the basis for the termination of the contract was that the contract was unlawful. the employee at the time was not in possession of a work visa. In that judgment, the High Court found that the termination of the employee's employment summarily was unlawful based on him not being able to be provided with a notice period. However, the employee in that case could have also approached the CCMA to challenge the fairness of his dismissal. And what the judge considered in that case was also the discovery judgment, and that all foreign nationals have the right to fair labor practices as enshrined in the Constitution and the Labor Relations Act, and they should be any termination of the employment should be effected in terms of a fair process and based on a substantive reason as well.
Okay, so what we've got is the discovery judgment in relation to fairness, and that waters down essentially to the CCMA. And now you've got this recent judgment that also calls into question the lawfulness of the termination, excuse me, the lawfulness of the termination of a foreigner's contract of employment and what claims could be faced by an employer that terminates the contract in the absence of either in circumstances that are unfair, in addition to being unlawful. So we've got two areas of risk, we see.
Yes, that's correct.
Right, and Sachin, just coming back to the point that you'd made. So the policy now effectively legislates what's been the position since the discovery judgment, which was probably over about 15 years now. So it kind of now puts that into legislation.
2008, I think it was, Imran. But it effectively says that this is one of the objectives that we seek to achieve with our labor migration laws. And you'll see in the Employment Services Amendment Bill that we'll touch on later, it expressly states, of course, that foreign nationals enjoy the same protections as South African citizens.
Okay, and I guess from I don't say from a philosophical perspective, but certainly from a legal perspective, that's to be welcomed. That we certainly need to maintain a rights-based model and ensure that when it comes to the employment of migrant laborers or foreigners, generally in South African workplaces, that there's a respect for such persons' rights. I mean that can hardly be criticized, I would think.
No, hardly. In fact, when we look at what the policy plans to achieve, right, one of the things that the policy plans to achieve is the prevention of exploitative practices against foreign nationals, right? So we see it as a way in which we can protect the economy as well, right? I think we're all familiar with the notion that the only reason certain foreign nationals are employed is because they can be exploited, and this certainly prevents that.
Yeah. Well, I guess that opens up a whole different avenue in relation to social protection laws and the like. But let's park that for the moment. Let's get to how the policy plans to achieve these objectives. What's the intent from that perspective?
Right. So with the prevention of these exploitative practices against foreign nationals, there's two other things. One is that the policy seeks to attract or retain critical skills needed in the economy. So this will be done by identifying the skills shortage and enhancing economic competitiveness. And it also seeks to protect job opportunities for South Africans in a more direct way. And we see this through the use of the quota system that's being proposed and through certain other restrictions on foreign nationals.
Now, this question of quotas, let's come back to it. We'll come back to it. I've got some questions and some comments in relation to the quotas, but let's park that for the moment. Let's just talk practically. What will this likely look like in the fullness of time?
All right. So a major component of the policy is the coordinated implementation of policy objectives across key ministries. And this is namely the Department of Employment and Labour and the Department of Home Affairs. So in other words, the policy recognizes that there's a need for cooperation across cabinet portfolios in respect of migration, and this includes immigration. Right. It will no longer be a home affairs or policing issue. The policy recognizes that immigration can be used as a tool to further economic growth if it's used correctly. And this marks a significant shift in South Africa's approach to immigration, moving us away from a fragmented or risk-focused and reactive approach to a more coordinated, evidence-based, development-oriented, and rights-based framework. So in short, the hope is that South Africa's approach to migration will be used as a tool to retain the skills we lack and desperately need without compromising opportunities for the South African citizenry. The policy also identifies the need for a clearer and more structured process for the hiring of foreign nationals. And this will obviously mean stricter regulation in recruitment practices, the need to prioritize South Africans in the labor market, and to place certain limitations on the employment of foreign nationals. Employers will also need to ensure that foreign workers are only hired if there's a proven shortage of local skills, and that all workers, obviously regardless of nationality, are treated fairly and provided with decent working conditions. But yeah, as I say, it will only be achieved through the strict monitoring of labor migrants and employers alike. Now, just to draw back to the policy itself, our constitutional court has, as far back as 2022, in the Raffoneke judgment, held that internationally the practice of reserving the right of occupational choice to citizens is not uncommon in democracies. So it certainly seems like it would pass constitutional muster.
Yeah, and that is a decision that it's a recent judgment of the Constitutional Court.
Yes.
What was it, about 2022 or so? And the principle in the Raffoneke judgment was that there's an international practice of reserving the right of occupational choices to citizens, and that's kind of a hallmark of democracy. So I think your comment is a fair one, that in relation to this aspect, and I'm leaving the issue of I'm leaving the question of quotas for the moment. Just at a very general level, the policy, once it becomes law and in the fragmented immigration laws become more coherent, this aspect of, inverted commas, I'm going to call it job reservation for citizens, is likely to pass constitutional muster. It's early days, but that seems to be the direction in which we're likely to go. Would that be a fair comment?
I think so, and maybe perhaps just to add on to that, Imran, I think logically it also makes sense, right? If we look at if you're a South African citizen and let's say you're working abroad, right? South Africa will always be your home, right? There's no way that you'd be kicked out of South Africa just for want of a job, right? So we do need to protect the South African citizenry, because we obviously have to ensure that as many South African citizens are employed, especially against the backdrop of what you just said about the high unemployment rates, the shockingly high unemployment rates.
Sure. So when you said you wouldn't be kicked out of South Africa, I had to think for a moment about our state president and how he has to defend that position. But fortunately, we don't have to talk those issues. Terence, can I just bring you back into this conversation with regards to a proven shortage of local skills? That's not an innovation in our law. What is the current position as we have it with regards to applying for a work permit with reference to this question of a proven shortage of local skills?
Sure. So in terms of the Immigration Act, one of the visa categories that we have is the critical skills visa. And the purpose of this visa is really to attract skilled individuals who have been identified as being, which skills have been identified in short supply. So these individuals will look at the critical skills list, and if those skills are on the critical skills list, will apply for those visas. But that's one way of trying to get those short skills into South Africa.
Okay. So that in many respects is then not an innovation. It's simply consolidating what we already have.
Yes, that's correct.
Okay. Then Session, let's get back to the policy, right? You mentioned evidence-based migration. The policy seeks to achieve the development of evidence-based migration. What does that mean?
Right. So one of the defining characteristics, obviously, of any economy is, of course, its ability to retain or attract critical skills. And as you've said, that's not new in our law, and it's not new in the South African context, right? But firstly, we obviously need to identify those skills. So the policy has identified the need to establish proper skills planning, right? Which is, it will be primarily the responsibility of the Department of Higher Education and Training. And it proposes a phased approach starting with existing instruments, such as the occupations in high demand list, which is the prerogative of the Department of Higher Education, and the critical skills list, which sits with the Department of Home Affairs. And we often use these lists, or rather we use these lists to facilitate the issuing of work visas. Now, the policy has identified that the current iterations of these lists are limited in relation to accuracy and relevance. Just as an example, the occupations in high demand list, which is prepared by the Department of Higher Education, is a list which is only updated once every 2 years, right? So it loses its relevance over time. The policy proposes developing a methodology for the review of these two lists and possibly the consolidation of these two lists based on effective evidence gathering and under the joint supervision of both the Department of Employment and Labour and the Department of Home Affairs. Now, part of the approach will also be the requirement that employers must develop skills transfer plans when recruiting foreign employers. So these plans should be tailored to the relevance of qualifications and skills brought by foreign employees. The policy also promotes the use of sector education and training authorities, or as we know them, SETAs, which will be earmarked as a potential avenue for the development of guidelines for the effective implementation of skills transfer plans. So what we also see is that employers may even be incentivized to embrace the policy's objectives. Now, a few of the other mechanisms would also include incentivizing highly skilled foreign workers to remain in South Africa, an aggressive recruitment process for the critically affected sectors and professions, the development of programs to maintain links with South African professionals abroad, and creating flexible pathways for their temporary or permanent employment should they return to South Africa, and the alignment of our National Qualifications Framework, or NQF, with the SADC Qualifications Framework. And this should facilitate the recognition and harmonization of skills and qualifications across the region.
So I mean, at a very broad level, I mean, the policy is quite laudable in respect of what it seeks to achieve. I guess, like most other things, it's a question of practicality and how it gets implemented at the end of the day. But Sachin, let's move away from this policy. We'll come back to discuss questions around how the policy envisages it's going to be enforced, because that becomes the next big topic. Lee, if we can bring you into the conversation on the Employment Services Amendment Bill. Let's talk about the link between the policy and the Employment Services Bill. But before we do that, right, just take us back in time and explain to us firstly, what is the Employment Services Act? When was it first promulgated, and what is its purpose?
Thank you, Imran. So the Employment Services Act was introduced as a parliamentary bill as far back as 2010. And at that time, the proposal for the introduction of the legislation was said to contribute to government's objectives for more jobs, more decent work, and sustainable livelihoods. And then the Employment Services Act was enacted about a decade ago in 2015, and its stated purpose was to, among other things, promote employment and improve access to the labor market for work seekers, provide opportunities to the labor market to gain work experience, improve the employment prospects of work seekers, in particular vulnerable workers, facilitate education and training for work seekers, again, in particular reference to vulnerable work seekers. And perhaps most importantly for today's discussion is to facilitate the employment of foreign nationals in the South African economy, particularly when the foreign nationals are required, in a manner, their contribution is required in a manner that gives effect to the right to fair labor practices contemplated in Section 23 of the Constitution. It does not have an adverse impact on the existing labor standards or the rights and expectations of South African workers, and where it promotes the training of South African citizens and permanent residents through those foreign employees' contribution.
So this Employment Services Act has been on our statute book since, what is it,
2015.
2015. So that's essentially for the last 10 years. But it, tell me if you agree. Well, Sarah, you can't disagree with me. Would you agree with this proposition that amongst the suite of employment legislation that we have on the statute books, the Employment Services Act is not one that has been at the forefront? I mean, it's certainly not something that comes to mind quite often or relied upon in activities on a day-to-day basis. Would you agree with that comment?
I would agree with that comment, Imran. I think it's probably why there has been now the proposal to amend the Employment Services Act through the bill, which Taryn will take us through in a moment. Because what the Employment Services Act sought to achieve, among other things, was to provide comprehensive and integrated free public employment services, coordinating the activities of public sector agencies whose activities impact on the provision of employment services, encouraging partnerships, including in the provision of employment services in order to promote employment, establishing schemes and other measures to promote employment, and providing a regulatory framework for the operation of what is known as private employment services. Now, you're right in that the Employment Services Act doesn't come to one top of mind when one thinks of labor legislation in South Africa. And that is why the enhancement and the modifications through the Employment Services Bill seeks to achieve what the initial stated objectives were that I've just mentioned.
So this concept of employment services, what just unpack that for us for a moment. What does it actually mean under the Act, under the current Act?
So employment services is a range of various activities. It ranges from recruitment and placement services all the way to the provision of temporary employment services.
Okay. And when you reference temporary employment services, it's colloquially labor broking.
Correct.
Okay. So effectively what you've got is employment services in the public sector and recruitment, let's call it that, in the private sector. That's the two extremes, as it were.
That is correct, yes.
Okay. So then getting back lead to the purposes of the Employment Services Amendment Act. How does the ESA, the Employment Services Act, seek to achieve all of its purpose?
Well, as I've mentioned, there's a suite of manners in which it seeks to achieve the purposes through various regulation of public employment services and private employment services.
Okay. Then, Taryn, let's then take the conversation to the National Labour Migration Policy again in the Employment Services Amendment Bill. So away from the existing statute, which Lee spoken about, to the Employment Services Amendment Bill that Cabinet has approved. What is the link between those two, between the policy and the Amendment Bill?
Sure. So policy itself cannot be enforced on its own. In order to give effect to a policy, legislation needs to be enacted.
Right.
So in this instance, the Employment Services Amendment Bill aims to give practical effect to the National Labour Migration Policy.
So the policy is the labor migration policy is at a high level that's set out in the policy of 2025, which goes back to, I think it was about 2022. And that policy objectives are now being fed into the legislation in the form of the Employment Services Amendment Bill, which will then which feeds in effectively to the 2015 legislation that we already have in the books. Is that a fair summary of what
Yes.
the legal framework is?
Yes, it is.
Got it. Okay, so what then is the current status, Terran, of the Employment Services Amendment Bill? So where are we currently with the bill, and where does it go from here?
Sure. So I think as recently as the 28th of May of this year, Cabinet announced that it approved the National Labour Migration Policy for implementation, and that it approved the Employment Services Amendment Bill for introduction to Parliament. Once the bill has been introduced to Parliament, it will be published for public comment and referred to the relevant parliamentary committee for amendment, or for debate firstly, and amendment if necessary.
Then let's talk the current Immigration Act, because that's the, I don't want to say that's the default position, because that is the position with regards to immigration. Where does the Immigration Act then sit in the scheme of what will now be the amendment of the Employment Services Act?
Sure. So I think from an immigration perspective, when we look at the purposes of the Employment Services Amendment Bill, it really seeks to achieve some consistency between the Immigration Act and the Regulation Act. So the bill really seeks to achieve consistency with all three acts in the employment of foreign nationals.
Okay, and from an immigration or from a foreign national perspective, let's call it that, what would you say are the key proposed amendments in the Employment Services Amendment Bill?
Sure. So there are quite a number of proposed amendments. I think a lot of them deal with an employer's obligations rather than that of a foreign national. But in particular, in terms of the bill, employers will be required to ascertain that a foreign national is entitled to work in South Africa and is entitled to perform the work in which they are employed. So this requirement is not anything novel. It's quite aligned with Section 38 of the Immigration Act, which imposes certain duties and obligations on employers in the employment of foreign nationals. Employers will be required to satisfy themselves that there are no persons in South Africa other than foreign nationals with the requisite skills to fill a particular vacancy before recruiting a foreign national to occupy that vacancy. Now, this requirement takes us back to the initial requirements of a general work visa, where employers were required to satisfy themselves that there was no South African citizen or permanent resident that could be employed from the local market before actually employing a foreign national.
Right.
Employers will also be required to prepare skills transfer plans in relation to all foreign nationals that they employ. Under the Immigration Act, and when applying for a work visa, this requirement was specific to an intra-company transfer work visa only, and not all visa categories, but it looks like all foreign nationals will need to have a skills transfer plan in place. Employers will also be required to employ foreign nationals on terms and conditions of employment that are not inferior to those of South African citizens and permanent residents. Now, of course, this is seeking to protect vulnerable workers. And employers will be required to retain copies of all work permits to ensure that the foreign national is allowed to be employed by that employer in South Africa. And of course, then there is the introduction of certain sectoral quotas in the employment of foreign nationals as well.
Okay. And quotas is a big topic, but we're going to park it for the moment. Lee, if we can get you back into the conversation, how does the policy seek to navigate the balance between addressing what is a real hot potato in South Africa, which is unemployment, while still ensuring that the country remains an attractive destination for skilled foreign workers? Because there's a tension between the two.
Yes, that's correct, Imran. The policy supports the introduction of a quota system to limit the number of foreign nationals employed in certain sectors, particularly in low and semi-skilled occupations in South Africa. And this is really in order to protect job opportunities for South African citizens, especially young South Africans, because if one considers there is a high youth unemployment rate in the country, as well as permanent residents of South Africa. But the policy also provides for certain exemptions and flexibilities where there's a clear evidence of skill shortages from amongst South African citizens. So the quota system that is then proposed by the policy is given practical effect through the proposed amendments to the Employment Services Act in the bill itself. And what the bill suggests is to grant the Minister of Employment and Labour the power to impose and enforce maximum quotas and sector restrictions for the employment of foreign nationals. And then the bill sets out that the proposed powers to be given to the minister in respect of quotas is to give the minister the power to apply any quota for the employment of foreign employees in one or more sectors, that there will be a notice issued that will set out what the specific quotas are. So the quota must set out which sectors, the notice must set out which sectors the quota applies to, which occupational categories the quotas will apply to, whether it's nationally or whether it's in one or another region in the country. The notice may also specify the period by which employers must comply with the quotas, and this may be differing periods for existing employers and newly established employers, because you can imagine the start-up employers might not be able to comply immediately with certain quotas that are put in place. And then lastly, there is the ability in the proposed amendments for the minister to exclude what is called small employers from compliance with the quotas. And the amendment also suggests that it doesn't define the term small employers, but it does say that the minister can in the notice, which is issued in relation to the quota, specify what constitutes a small employer for purposes of the quota that's going to be applied. And what is also interesting to note for employers is, should the Employment Services Act bill be amended in its current form, is that and the sectoral quotas for the employment of foreign nationals are then imposed, there might have to be some kind of balance that is struck between the targets that are set by the minister in terms of a notice in the Employment Services Bill and the current numerical targets which exist in the Employment Equity Amendment Bills and the ensuing sectoral targets that then exist. If one considers the numerical targets that were issued under the Employment Equity Amendment Bills on the 15th of April 2025, you'll note that there is a proviso or a note that is made that the 5-year numerical targets in that for the employment equity purposes were not intended to add up to 100%, because the sectoral targets there exclude non-designated groups, which, if you look at it holistically, is males, white males with no disabilities, and foreign nationals. So those groups are still considered to be part of the workforce, but they are not included in the sectoral targets.
Okay, so let's just stick with that consideration for a moment, Lee. So under the Employment Services Amendment Bill, there's going to be an introduction of quotas for the employment of foreign nationals. Is that correct?
Yes, it gives the minister the powers to do so.
Okay, and under the Employment Equity Act, there are what we now know to be sector targets that employers need to work towards.
Yes,
that's right. All right, so we've got There's two pieces of legislation, one having a quota and another one having a sector target. Now, I said we're going to park this issue of quotas, and here we are talking about this contentious issue. I've got my views about quotas. There is already existing authority in the Constitutional Court that has found that the imposition of quotas is unconstitutional. So if we pivot to the Employment Equity Act, we know that the minister moved away from and distances himself from any consideration that sectoral targets are quotas. So they very clearly the DEL puts out that it's not quotas under employment equity legislation, it's sectoral targets. But in relation to the employment of foreigners, the position is, well, it's not going to be a sectoral target in relation to foreigners, it's going to be a quota. So I suspect there's going to be some sort of legal challenge in relation to quotas when it comes to the Employment Services Amendment Act when that eventually sees the light of day. Would you agree with that? Would you agree with that assessment, or you think it's not likely to be?
I think it is definitely possible, but perhaps that could also be through the parliamentary process, a point that can be made that should the Employment Services Act be enacted in its current format, there might be constitutional challenges to the issue of a quota system, which, as you've correctly mentioned, has been said by our courts to constitute in certain circumstances unfair discrimination.
And we know that there is currently a challenge to the employment to the Employment Equity Amendment in relation to the sectoral targets that the DA has launched. That's at least one of the more foremost pieces of litigation attacks against the legislation, and one of the attacks is that the sectoral targets essentially amount to quotas. So this is likely to be very contested terrain in time to come.
That is correct. And perhaps also just to point out one additional thing, Imran, is that it's interesting that the policy and the Employment Services Amendment Bill don't specifically mention which sectors are going to be targeted by these so-called quotas. However, in Cabinet statement on the implementation of the policy, there was specific mention of the agriculture, hospitality and tourism and construction sectors. So once the bill comes out in its amended form, it is likely that those are the sectors that will be potentially targeted by the so-called quotas.
Okay, so the intention is we understand it currently is to be narrow in relation to sectors, but the minister obviously has the power to go broader than the narrow focus in the fullness of time, as it were.
That is correct, yes.
And then I just want to close off on this quota issue, and I'm delighted by your conceptualization, Lee, that HR practitioners and employment lawyers came close to mathematicians when we all worked out that under the employment equity sectoral targets that these things were not adding up to 100%. So just unpack that aspect again for us so that it's clear to the participants. You say that it does not add up to 100%. That remains the position. So that was one of the issues that we picked up. I think it was about 2 years ago when the sectoral targets were first being floated, that they were not adding up to 100%. They currently don't add up to 100%. So just explain to us where the delta you see filled in relation to employment equity.
So what numerical targets that have been issued specifically set out, it was never intended to add up to 100% because those numerical targets still consider, obviously, individuals from non-designated groups, which really are white, able-bodied males and foreign nationals to still be part of the workforce. So it's not to entirely exclude them from the workforce in the 5-year numerical targets that have been set. So there is room for them still in the workforce.
Okay. So the employment equity sectoral targets don't add up to 100%. They obviously apply to designated groups. So that's your sectoral targets to fill in relation to designated groups. What you're saying is white males sit outside of the designated group, but foreigners would then fill in would fill in under the Employment Services Amendment Act, part of the quotas in for the purposes of meeting those numerical the sectoral targets when you read them together.
Yes.
Is that a fair summary?
Yes, that is.
Okay. Okay. So HR practitioners are not, as my middle daughter says, never going to get away from mathematics. Clearly, we're going to have to sit and work all of this out on very complicated formulas in relation to achieving what government seeks to achieve in relation to quotas and sectoral targets on the other extreme. But then let's move away, leave from quotas and sectoral targets. Let's talk about foreign business visas. What does the policy propose in relation to the imposition on the restrictions on this visa category? Is there any imposition, or how does it deal with that?
So the policy notes that closely related to the issue of quota restrictions on the employment of foreign employees is the question whether there ought to be a requirement that must be made to the composition of businesses that are currently employing foreign nationals or that are owned by foreign nationals. So in other words, it requires more of a holistic consideration of the entire economically active population of foreign nationals in South Africa when issuing or renewing business visas or permanent residence visa for a permanent residence permit for business person, work visas or corporate visas. So with this in mind, the policy should be seen more as complementary to other existing interventions, such as the enforcement of a list of sectors where foreign nationals cannot be allocated business visas, or the proposed amendments to the National Small Enterprises Act, which seeks to limit foreign nationals from establishing small, medium, and micro enterprises and trading in certain sectors. And this is obviously an amendment that was considered having regard to many issues that we've had recently with undocumented foreign nationals that have been operating so-called spaza shops. And it's really trying to regulate more strictly what is a very informal industry in South Africa at the moment. And there's also quite a unique idea to facilitate the regional integration within the SADC region, as you mentioned upfront, Imran, at the beginning of the webinar, through the creation of special visas. So the policy notes that the Department of Employment and Labour supports the creation of these special visas that have been proposed by the Department of Home Affairs for piloting. And these special visas are a special work visa in the SADC region, special traders visas, and the SADC small and medium enterprise visas. So the visas will be explicitly designed to include informal cross-border trading, as well as for traders or workers in the informal economy who operate for their own account. And then lastly, the policy also highlights in a recent OECD and IOL report that looked at the contribution of immigrants to developing countries' economies, that at a firm level or corporate level in South Africa, foreign-born workers can represent up to 40% of staff complement under corporate permits in South Africa. So once again, it's the issue of balancing out the right of South Africans to work and the ability to reduce the unemployment in South Africa for its citizenry, as well as the right of foreign-born workers to work in South Africa.
Okay. Thanks for that, Lee. I mean, there's a lot to unpack in relation to what the intended purposes are. Terren, if we can bring you back into the discussion, we touched on skills transfer plans, right? And in relation to the employment of foreign nationals, that is not an innovation in relation to the Employment Services Amendment Bill. And what is the intention going forward in relation to skills transfer plans? Firstly, where do we sit on that currently in our law, and where is it likely to go?
So currently in our law, there's no legal requirement for every employer to develop skills transfer plans in relation to every foreign national. I mean, it is a requirement under the intra-company transfer visa in terms of the Immigration Act regulations. The Employment Services Bill seeks to implement the requirement for skills transfer plans to be created by every employer in relation to every foreign national that they employ. The bill in its current format doesn't set out requirements of what these skills transfer plans will look like practically or what will be required from employers in this regard. However, it does state that the minister may make regulations setting out these requirements. I think from the skills transfer plans that we have prepared under the Immigration Act, employers may need to, in preparing their skills transfer plans under the Employment Services Amendment Bill, may need to, as a first step, identify the skills beneficiary or the person that would benefit from the skills transfer, either South African citizen, a permanent resident, or refugee. Then the employer will need to identify what skills need to be transferred, the timeline for transferring those skills, and then the method for transferring those skills as well. Yeah.
So we're then going to be moving from a narrow requirement currently in currently the position is one category of visa, and it's now going to apply across the board to all categories of foreigner work permits.
Not necessarily foreigner work permits in terms of the requirements of the actual visas, but in terms of the employment of foreign nationals, it will be required for all employers to implement.
Okay, I got it. So the intent is not necessarily linked to obtaining the permit, but there'll be a requirement that there be a skills transfer plan that's put in place. And I guess it gets back to one of the initial points that was made, that there be a protection, or that there be a protection of jobs, firstly for citizens, and then to fill the gaps thereafter, unless you're looking at a very scarce skill. So it seems that's the building blocks of the amendments. Is that a fair summary?
Yes, it is.
Okay, then Sachin, let's get back to this question on enforcement. Just talk us through enforcement and what the intention is with regards to enforcement.
Thanks, Imran. So look, enforcement will be multifaceted, right? First, we have the legislative aspect, and that's the aspect that Lee and Taryn have touched on already quite extensively. But this in effect entails the enactment or amendment to legislation, which at this stage seeks to vest the minister through the Employment Services Amendment Bill with the necessary powers to regulate sectors or industry through quotas and the like, right? And then we have the executive functions of the Department of Employment and Labour, which will take the lead in identifying labour market needs and setting priorities in particular labour markets, whilst the Department of Home Affairs will continue to manage border control and the issuing of visas.
Now, talking about the Department of Home Affairs, I mentioned new brooms and old brooms. There's something that the Department of Home Affairs recently announced, Operation New Broom, which was to combat illegal immigration and the use of biometrics. So talk us through what that's all about.
Right. So Operation New Broom it's an operation which was launched by the Department of Home Affairs. It was launched on the 21st of May 2025, if I'm not mistaken, in the city of Cape Town. Now, what's interesting about Operation New Broom is that it was technology driven, right? It was an initiative to arrest, convict, and deport illegal immigrants who were occupying public spaces in the city of Cape Town. Using advanced biometric technology, they were able to verify immigration status, the immigration status of individuals. And this, they say, they laud as something which would reduce the risk of the use of fraudulent documentation. In its first phase, Operation New Broom has resulted in the arrest of approximately 25 suspects who illegally occupied land in District 6, Cape Town. And we see in the policy that it essentially encourages the use of technology to achieve its objectives. So, for instance, the policy mandates improved digital coordination across ministries and other bodies, right? So, Operation New Broom provides us with insights into one of the ways in which we will achieve digital coordination and how that would obviously be implemented. With the sharing of information, obviously, also comes the enhancement of digital record keeping, right, for the purposes of monitoring and compliance and enforcement. And just last week as well, we saw the arrest of I think, about 50 undocumented foreign nationals in a factory in Kwadukuza. This is in KZN, which came as a result of joint efforts between the Department of Employment and Labour and the Department of Home Affairs. The KwaZulu-Natal Premier actually stressing the importance of intelligence gathering in South Africa's efforts to properly monitor and enforce proper migration.
So there's I would say over the last 18 months a sharpening of the of focus in relation to enforcement in relation in respect of immigration legislation. We've certainly seen that over the last, I said 18, maybe it's 18 to 24 months, but it certainly carried into 2025 with New Brooms as it were, Sashin. Then we're reaching the top of the hour. Terren, if I can ask you, from all of the discussions, what would you say to our participants today would be the key takeaways?
Sure, thanks, Imran. So I think there are quite a few key takeaways, but I'll try and just identify the most important ones. So as previously mentioned by Lee, in terms of the Employment Equity Act, employers need to consider that should the Employment Services Amendment Act be enacted and the sectoral targets, quotas for the employment of foreign nationals be implemented, a balance may need to be struck between the Employment Equity Amendment Act and the Employment Services Amendment Bill. In terms of the national labour migration policy, and due to the high unemployment rate in South Africa, the policy supports the principle that at least 60% of South Africans and citizens and permanent residents need to be employed by a specific employer, subject to the need to conduct proper market analysis on the issue or to review the set percentage. Employers also need to demonstrate that they've tried to recruit South African citizens, permanent residents, and refugees first before recruiting any foreign nationals, unless they are in highly skilled occupations and the occupations are in high demand. And employers operating in the identified sectors such as agriculture, hospitality, tourism, and construction are encouraged to prepare for the introduction of sectoral targets on the employment of foreign nationals by reviewing their current workforce composition and recruitment practices, ensuring or implementing a robust verification process to ascertain the ongoing legal status of any foreign nationals that they do employ. They should develop and maintain skills transfer plans in relation to all foreign nationals that they employ. And I think whilst the Employment Services Amendment Bill hasn't been implemented yet, employers are advised to begin reviewing their employment policies and practices in anticipation of the new requirements in relation to the employment of foreign nationals. And I think importantly as well, while the Employment Services Amendment Bill is still a long way from being enacted, employers should participate in the public consultations, especially in regard to quotas that may impact their sectors.
Fair points. Thanks, Terren. We were hoping that we'd be able to take a few questions from participants, but I see we literally a minute away from getting to the top of the hour. That leaves me, Terren, Lee, Sashin, to thank you for your I was going to say your wisdom and your inputs and thoughts. I'm not joking, Sashin, for the wisdom. There's a fair bit in relation to the background to where all of this comes from, for putting that together and making it somewhat easily digestible, so that at least after this webinar, we have a better idea as to what the issues are, and is Terren has quickly identified what the key takeaway points are, and as Lee's picked up on these questions of quotas and sectoral targets, is making sense of where all of this fits in, how to practically implement that in the life cycle of a business. To our participants, thank you again for making yourselves available for in joining us on this webinar. We enjoy putting it together, and it's certainly delightful to have you involved with us in yet another one of the webinars in our continued employment and immigration law series. Thank you. Wishing everybody a pleasant day ahead.
Thank you.